5, record index 164. In that contempt order, Cassandra Holmquist was held in contempt of court. She was ordered to fully and scrupulously comply with the parenting plan. The court ordered her imprisoned and committed to the Sutsman County Correctional Center for a term of 30 days imprisonment, which was stayed.
Right off the bat, this is serious. The judge already found Cassandra in contempt and even ordered jail time. But here's the key twist. The sentence was stayed. That basically means jail was put on hold, giving her one last chance to follow the parenting plan. Courts often do this when they want compliance, not punishment. But it also signals that the judge is watching very closely now.
For a period of time up to 6 months. She was given a 1-day credit for actual time she had previously spent in custody related to her contempt. She was allowed to purge her contempt and avoid imprisonment by scrupulously complying with the parenting plan in the court's judgment, record index 95, for 6 months. From October 15, 2025, or until April 15, 2026. The court explained in its order what would happen if Ms. Holmquist failed to comply with the parenting plan. The court further ordered Cassandra Holmquist to complete a parenting education class no later than December 15, 2025.
Missing a court-ordered parenting class might sound minor, but in family court, this can be huge. Parenting classes are usually tied to the child's best interest, which is the court's #1 priority. So when someone skips that requirement, the court can interpret it as ignoring responsibilities toward the child, and that can escalate fast.
The court referred the parties to mediation. Thereafter, on December 18, 2025, the court had received notice from the clerk's office that the parenting class had not been complied with. An order to show cause hearing was scheduled for January 8. On December 23rd, 2025, Ms. Holmquist submitted 2 letters to the court, neither of which appears to have been served on other related parties. The court held a hearing on January 8, 2026, at which time Ms. Holmquist was read her contempt rights. Ms. Holmquist requested a continuance and requested the appointment of counsel because jail was a potential consequence for her violation. The court appointed her counsel and continued the hearing to today's date. In the meantime,
now listen carefully because the judge is about to explain 2 different types of contempt, and this distinction matters a lot. Remedial contempt is meant to push someone to follow the rules moving forward, while punitive contempt is straight-up punishment for past behavior. Translation: one tries to fix the problem, the other makes you pay for it.
Ms. Holmquist filed a certificate of completion, record index 181, of the Parents Forever online course, which was completed December 19, 2025. Together with a report from Essential Health, record index 182. So Ms. Holmquist, for today's hearing, you do have the right to be informed of your rights again for a contempt proceeding. The purpose of Remedial contempt is to impose a sanction conditioned upon performance or non-performance of an act required by a court order to induce compliance with the court's order. And the primary purpose of punitive contempt is to unconditionally punish contemptuous offenders and vindicate the court's authority. Contempt includes intentional disobedience, resistance, or obstruction of a court's order, authority, or process. The intentional refusal to produce a record, document, or object after being ordered to do so. Among other things, the court must first determine whether remedial or punitive contempt is appropriate. You have the right to be personally present in court. You have the right to reasonable written notice of any allegations and in order to show cause or warrant of attachment. You have the right to reasonable bail if a warrant of attachment is issued. You have the right to attorney representation and consultation. You always have the right to hire your own attorney. You always have the right to represent yourself. If jail is a potential consequence, you do have the right to the appointment of a public defender. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing and an opportunity to be heard. The standard of proof and burden of persuasion is on the moving party. The moving party must show for remedial contempt clear and convincing evidence, and for punitive contempt, the standard of proof is beyond a reasonable doubt. There must be willful, intentional, inexcusable, and unjustifiable conduct, and the defendant bears the burden to prove any defenses such as justification or impossibility. The rules of evidence apply in today's proceedings. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent. You have the right to present evidence, call witnesses on your behalf, and to use the court's subpoena power to force those witnesses to appear. Ms. Holmquist, do you understand your rights?
Yes, Your Honor.
Do you have any questions about your rights?
No, Your Honor.
Have you received a copy of the order to show cause?
Yes, Your Honor.
And so you understand the allegation against you is that you did not comply with the court's previous contempt order in doing that parenting class by December 15, 2025.
Yes, Your Honor.
All right. And thereafter, it looks like you've done it, but you didn't comply with the court's order that gave you 2 months to do it. Right?
Yes, Your Honor.
Do you admit or deny that allegation?
I did get it done late, Your Honor.
So you admit to that allegation is what I'm getting from you?
Yes, Your Honor.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to that allegation?
No, Your Honor.
Do you understand that you have the right to have a contested hearing on that matter?
Yes, Your Honor.
And do you waive that right, or would you like a contested hearing?
Waive that right.
Okay. Anything else that you'd like to tell the court concerning that behavior?
Her explanation focuses on money problems and scheduling conflicts, and those can sometimes work as partial defenses. But courts usually expect parties to communicate early if they're struggling to meet deadlines. Waiting until after missing the order can make the excuse feel weaker, especially when there's already a history of delays.
With the time frame of getting the class done, I had originally registered for the online class that was to be scheduled for the 10th through the 12th of December. The 8th through the 10th of December. Upon the 7th, I had received an email that the class was full. So I had attempted to re-register for the next upcoming class as it was in my price range at the time frame. And they had informed me it was going to be scheduled for January 10th through the 12th, where I had then reached out to get the self-paced class, which was an additional fee. So I ended up having to work an extra shift to be able to afford both child support and the class, where I did pay and complete the class upon my payday, which was the 19th of December. I did get it done at the soonest of my convenience, and I do apologize for not being done within the time frame.
Ms. Holmquist, here's sort of the frustration that I've had with you.
This is a turning point. The judge is no longer just reviewing one missed deadline. He's looking at pattern. In family court, repeated noncompliance can damage credibility fast. And once a judge believes someone only follows orders under threat, the court often starts moving toward harsher enforcement.
This isn't the first time that we have had to take time out of the court schedule and have hearings repeatedly to get you to file things and to do things that are required. If you recall, I think it was 3 times we had a hearing where I directed you to file an answer to the court. We had to continue several hearings because you had not done so. The parenting education class was ordered as part of the pretrial order for it to be done before trial. You didn't do it then. It was ordered as part of the judgment. You didn't do it then. It was ordered as part of contempt. You didn't do it then. So this has been ordered now. Case has been going on for about 18 months, and it's been ordered for about 17 of those 18 months. And it takes the threat of jail to get you to do things. I know and I appreciate that you've done it now, but should there be no consequence for your repeated failure not to follow my orders over and over and over and over again, what am I supposed to do with that?
I apologize, Your Honor. It wasn't my intent to not get it done in time. I have recently, the last few months, been dealing with some financial struggles due to constant medical.
But it's not been just the last few months. It's been over and over and over and over again. What does it take to get you to follow the order? I mean, it's not a suggestion. The title of the document is order. That should be telling you something. That this is an order. It's not a suggestion. It's not a when I feel like it. It's not when it's convenient for me. An order is an order. And you have, throughout the case, flaunted my orders and refused to comply with them. Where does that leave me? Am I supposed to just say, I guess that's okay?
No, Your Honor.
So what do you think I should do? I'm going to give you an opportunity, Ms. Kuzia, but that's more of a rhetorical question. And I want Ms. Holmquist to understand there are continuing obligations under the order. And we're not going to continue to play these games with not following the order. When I said scrupulously comply with the court's order, what I meant was I wanted you to read it, and I wanted you to say, what haven't I done that was ordered? And I wanted you to say, what am I going to do to make sure that I'm complying with this? Because if you don't, we're not going to do this game again where I continue order to show cause hearing for 2 or 3 months to allow you to comply late. We're done with that. You have burned up all of my patience when it comes to delaying matters so you can eventually comply when you finally realize that there are consequences for not following the orders. I'm not saying that I'm going to prejudge any issue. I'm not saying that I'm going to find you in contempt immediately, but I'm telling you my patience is exhausted when it comes to delays in complying with the court's orders. Do you understand?
I understand, Your Honor.
Is it going to happen again?
No, Your Honor.
Do you understand fully the consequences of what happens if you fail to comply with the court's orders in the future?
Yes, Your Honor.
And just so you won't know right now, I am not going to find good cause to continue to delay the matters because now this is the second, in fact, it's the 4th contempt hearing that we've had. because the first time I found you in contempt in October, that was a continued hearing to allow you enough time to get an attorney. And today's date was the second time post-contempt. So this is contempt of a contempt order. It's the second time that the hearing has happened. So you have now been read your rights to an attorney at least 4 times, and I know it's been more than that, but at a minimum, those 4 times. If there is another order to show cause, it won't be show up to the hearing and then ask for an attorney, because you now are well aware of your right to an attorney. We will not be delaying to give you additional time to comply if you're either going to be in compliance or not. So I'm putting you on notice this second. No more games with my orders. There will be consequences if you fail to file or fail to follow the orders.
Yes, Your Honor.
There won't be delays. I won't find good cause. Things will move much faster in the future because my patience is exhausted here. Do you understand the obligations under the court's previous judgment and orders for contempt?
Yes, Your Honor.
Anything you want to add, Mr. Stegman?
I just want to make this situation as easy for our son as possible. He has his visitation with his mom, and he loves both of us as, the same. We went through mediation. We come to an agreement to move the time on Wednesday visit, it's 3 hours, but an hour earlier so we can get him home an hour earlier due to how late the visit was going for him. So she is trying to do the best she can to flow with what the order says when it comes to visitation. But everything else, it seems like you said in 2 hearings ago, all she's doing is walking out of this courtroom and thumbing her nose in all sense. I mean, she does good for 2-3 months. She's still in contempt on child support. I don't know where she's talking about having to work extra shifts so she can afford a class and pay child support. I haven't received a child support every single month I got one last month for $70-something, and one couple months before that. So it's not like she's working and trying to follow it. She's just picking the easier parts out of it. And I have worry that if something doesn't happen, we're gonna be back here in 4 months. We're gonna be back here in 6 months. And you said that you've had to take time, or she's taken time out of the court schedule. She's taken time out of her attorney's schedule. She's taken time out of my schedule. And that's just my worry, that if nothing is done, it's just going to continue. And that's all I got.
Thank you. Ms. Kuznia, anything from your perspective?
Yes, Your Honor. Obviously, I am somewhat new to this case, and I can understand that potentially there is some frustration from previous contempts. I have only honestly been appointed to represent her in this one. So my understanding here is that Cassandra wanted to get this parenting class done. She's been diagnosed with fibromyalgia recently, has been struggling to work, as noted, as evidenced by the Essentia letter that was submitted to the court on January 28th. She has very limited ability to work. They're limiting her to work, I believe it said 5 hours a month. And so there's just financial struggles is the main concern here, is that She wanted to get the parenting class done. She also understands that she has child support obligations and she does not want to be, held in further contempt for not abiding by those child support conditions. So she made that a priority, is my understanding. While she knew she needed to get the parenting class done, she had to pay more for the self-paced class. That is the one that she completed. So, this was important for her to get that done. This was a priority, and she knew that. She did get it done, and I understand it was 4 days late, and she understands the importance of deadlines. However, we'd ask you not to hold her in contempt at this point, as the condition has been met. She did go to the parenting class, so any sentence given, any contempt that you hold her in at this point would just be punitive and punishment for her. She's struggling financially, but she's trying her best and will do so going forward.
So Ms. Kuznia, the court ordered that to be done on April 9, 2024. That's how late it is. So I understand that it's not the first time that it was ordered, but the argument that she lacked the capacity and that's why it's 4 days late rings pretty hollow when it was ordered to be completed within 30 days, at least 30 days before the trial, but it was ordered in paragraph 11 on page 2 of the court's scheduling order, first issued on April 29, 2024. Here we sit February 4, 2026, so almost a full 2 years later. That's really a problem.
Yes, Your Honor, I understand that. I would also, I would ask the court to, strongly consider the fact that it has been complete at this point, and at least consider that on my client's behalf.
Anything else?
Just imposing any fines or fees again would just further set Ms. Holmquist back. She's struggling financially already the way it is to comply with the child support provisions. As noted before, she's having difficulties working at this point. So again, I would ask that you not hold her in contempt, not impose any fines or fees or jail time in this matter. Thank you.
Ms. Holmquist, anything else?
No, Your Honor.
Well, again, this was a remedial contempt proceeding. I didn't indicate I would consider punitive contempt in this proceeding. I'm telling you right now, if it happens again, if there's another violation of my order, it likely will be punitive if we have a contempt proceeding. I will consider it a punitive hearing, and I will potentially impose punitive sanctions. But the primary purposes of remedial contempt is to impose a sanction conditioned upon performance or non-performance of an act required by court order, or to induce compliance with the court's order. At this time, Ms. Holmquist is in compliance with the court's order with respect to the parenting plan. The issue of child support is not properly before the court at this time, Mr. Stegman. And so she very well may or may not be in contempt for not following the child support provisions, but that wasn't alleged in the order.
And here comes the final ruling twist. The judge is choosing not to hold her in contempt, not because she followed the order on time, but because she eventually complied. However, this is basically a courtroom warning shot. The judge is clearly signaling that if this happens again, the next hearing could shift from corrective action to punishment, and jail would be very much on the table.
Show cause, and because Ms. Holmquist has the right to be informed in writing of the issues to be addressed at the hearing, and that was not in writing as of the time of that order to show cause, it's not properly before me, so I don't consider the child support issue. If you're struggling to receive child support as ordered, Mr. Stegman, I believe child support will help you enforce that action, because I'm certain that the child is receiving benefits through the state, through one of you. So I think those rights have been assigned to the state of North Dakota. ask the state of North Dakota's Child Support Enforcement Agency to assist you if you're struggling in that respect. They bring child support contempt proceedings in front of the court every week. So certainly if that's an issue that can be addressed in the ordinary course of court business, but it needs to be properly before the court. All that's in front of the court right now is the parenting course, which I ordered with the intention of providing for the best interests of your child. I wanted both of you to go through that course because both of you should have that parenting education to better assist you in providing for the best interests of the child. That was the court's intent. That's the purpose that it's in my scheduling order. That's the purpose that I ordered it as part of contempt and as part of the judgment, was to provide for BS's best interest. So that now has been done, eliminating the need for remedial contempt. So right now, Ms. Holmquist, I am not going to find you in contempt of court. I'm not going to impose a remedial contempt. Technically, you were in violation, and you've been in violation for a long time. And I'm telling you right now, it better be the last time or next time, punitive contempt sanctions, which are either fines or jail. And we already know that fines are likely to be ineffectual because of your financial situations. So what option does that leave the court? You understand what that means.
Yes, Your Honor.
So if there's another issue, it likely will be punitive contempt. And again, the only two options under the statute for punitive contempt are fines or jail, and fines aren't likely to be effectual for you. So that means the only sanction the court will have available to it will be to hold you in jail.
Yes, Your Honor.
That's not my preference, because not only does that affect you, it affects your employer, it affects your landlord, it affects your child, it affects lots of relationships. That's not what the court wants to do, but I'm telling you, that's where we're at procedurally. I don't want to do it. Don't make me do it. Understood?
Yes, Your Honor.
Anything else from any other party?
No, Your Honor.
No, Your Honor.